May I please? I need to mention for listing of a matter is under admission column on Friday.
Friday?
Friday.
Why? What is the matter about?
I will not non-payment of contactors bill. We are respondents are my lord, state of Maharashtra. Despite meeting, they are not here.
Respondent in the state of Maharashtra?
Yes. So it may be can be disposed of. So, on Friday. I am applying.
Item number 4 of today's list, madam.
Yes.
I wait to withdraw, madam. Item 3. Item number 3, madam.
Item number 3.
Yes, madam. Want to take that, madam.
Okay. Mr. N.K. Kalita,
Yes.
Learned Counsel for the petitioner, prays that he may be allowed to withdraw the petition. Who is for the other side? Mr. S.S. Roy appears for the state respondent. The prayer made by the petition's counsel is allowed. The writ petition is dismissed as withdrawn.
Need please, your lordship. Lordship, prayer for withdrawal of a matter.
Item?
Well,
Acha, tomorrow.
Tomorrow.
Okay.
I'm obliged.
Your lordship. Lordship, item number 13 from the daily list. Lordship, kindly pass over the matter for the daily.
Item number
13 from the daily list. Lordship.
34? 13.
13, your lordship. 1 seat.
Why should I pass over?
Your lordship, there need to be certain correction from the within the cost.
Huh?
There need to be made certain correction from our end, your lordship.
You're for the petitioner?
Yes, your lordship.
You see, first of all, you have not submitted your amended cost item. Secondly, you have not taken steps.
Your lordship, senior counsel is out of.
You call the senior counsel. You call him.
Excuse your lordship. I'm praying for inclusion of one matter in the list for compensation of the petitioner for land acquisition. The land of the petitioner was acquired,
Land acquisition case is this bench.
settlement by the state.
I think bench 5, is it? Land acquisition matter before this bench.
For compensation.
Bench 5, I think probably. I don't have this type of cases here.
Apologies.
Item 17 for withdrawal.
Please, your lordship. Your lordship, I am very sorry to say that this matter has been not in fact was but wrongly mentioned for withdrawal. It may be fixed for orders, sir.
Who are you?
I am the petitioner, your lordship.
What's your name?
S.I. Akan.
S.I. Akan.
Yes.
Okay, right. Mr. S.I. Akan, learned counsel for the petitioner submits that
Continue.
he has made a mistake in asking for listing the matter under the withdrawal column. He submits that the issue is very much alive as on date. Good stuff. Next paragraph. On perusing the last order dated 6/9/2024, it is seen that notice was issued and that steps were to be taken by the petitioner's counsel. By the petitioner. Good stuff. Have you taken steps?
Yes, Lord.
Huh?
Lordship, I have taken a step. The step has been taken.
Office note dated 7/9, no, the office note dated 7/9/2024 does not, wait, 18/9. Okay. Office note dated 18/9/2024 states that notice has been issued to the respondents number 1 and 2 by registered post with AD on 18/9/2024. Await service report. This is the matter after 2 weeks.
So,
Item 1.
We heard Mr. L. Mohan, learned counsel for the petitioner, who submits that the order dated 18/11/23 passed in WPC 4829/2023, by which the respondents were to verify the vehicle hire charges has not been complied with till date. Issue notice returnable in 5 weeks. Petitioner will take steps for service of notice upon the respondent by registered post with AD within 3 days. Release the matter after 5.
Item two,
This matter may kindly be taken up after some time, Lords. After some machinery.
What has happened to the representation?
We have disposed it of by an order dated second of November, last Saturday. And they have placed it by way of an affidavit date filed today morning. To bring it on record.
Machinery would like to appear in this matter, Lords. After some time, Lords. Please on legs.
We have pointed out the fraud and we have rejected their prayer.
No, but then he's saying that for that already that penalty was imposed.
He said that the moment you debited that penalty amount in the account, no opportunity was given to me for a hearing. So no notice was issued, no nothing. For that 1 crore.
Yes, for that 1 crore.
Now he filed the representation after your lordship's order, and we have disposed it of by his order. We have
Ah.
pointed out the entire scenario, the fraud committed by him, and we have rejected. And we have said that we'll keep that amount. And till date, sales and supplies have not been restored.
Sales and supply not been restored. So we have to modify that order.
So they have filed an affidavit. They have brought some additional documents also. Just to come on record matter, they would fix it on Wednesday or Friday.
The kindly takes it after some time, Lords.
After some time we will.
After some time. I'm deeply obliged.
item four.
Allotment of a bid in a market, my lord,
Allotment of,
of a commercial space, my lord, in a
Yes,
market, my lord, this
yes.
is called bid, my lord.
yes,
Then, my lord, what happened, page number 14, it was for 5 years. The lease was for 5 years,
page number,
14, 1-4. That is 29/4/16 to 21, my lord.
yes,
What happened, my lord, page number 23, my lord, that during pendency of the
just
lease,
a minute.
clause number, my lord, 6.
Yes,
Then, my lord, page number 23, within the lease period, a notice was issued to vacate the, my lord, bid.
yes,
This honorable court, petitioner has approved page number 24,
yes,
and this honorable court in the issued notice and in the interim protected the petitioner from eviction.
yes.
Then, my lord, he has been paying the rent regularly, but they are not renewing the lease because it is up to 21.
So you see, Mr. Counsel. You have been asked to evacuate
Yes, yes,
that land,
yes.
that 17,
Yes,
that
yes,
number,
yes.
correct?
yes,
You have already put that to challenge.
yes.
Then,
I have challenged the eviction order.
then where is the question of allowing you to extend your license when your eviction order is under consideration in another writ petition?
My lord, that petition was during the lease period, my lord.
Maybe,
During the lease period,
maybe,
2020, and the lease
Maybe.
expired on
Maybe.
21.
but unless that is decided, you see, if in that writ petition,
Yes.
if that writ petition is allowed, well and good, then only this can be considered. But if that writ petition is dismissed,
Yes,
the order evicting you is upheld by the court,
Yeah.
then this writ petition is infructuous. So this writ petition appears to be premature.
no, my lord, that writ petition, my lord, was filed during the pendency of the lease period.
Maybe,
So, my lord, if that is allowed, my lord, but this non-renewal may affect my lord. So my humble prayer to issue notice and take with the earlier petition, my lord. This honorable court.
Yes, Mr. Datta, what to do?
My lord, already two cases are there.
Already two cases?
No, one, my lord.
One
One
disposed of, my lord.
I one disposed of.
2980. No, my
That
lord.
was suppressed.
Oh, that is
No,
suppressed.
that was suppression. That was, I think, my lord, I think withdrawal, my lord.
That is not mentioned here.
No
I
mention.
have mentioned, my lord, full stop.
In 2021, my lord.
Ah, yes. MJ Kadir, same lawyer.
Same.
KD Sharma's case. Yes, so what has happened to this?
My lord, after some time, maybe may not take care of this matter, my lord. I will go through this matter. After some time, after some time, I will take care of it. Because my
After some time.
pending, all right.
Item 5.
Yes.
The godowns of Amul have been sealed, my lord, by the JMC authorities. Now, my lord, we had a subsisting trade license, my lord, which your lordship finds at page 45. Now, despite that, there was a show cause notice issued giving us 7 days time to show cause, my lord, but simultaneously
Let us see the show cause.
page 29, 30.
Yes. This is in, okay, page 29.
29, 7 days time was given, my lord. No, they're alleging some irregularity in the license, my lord. But at page 45, your lordship will find that there are subsisting licenses. Now, what we've gathered is, my lord, we are not sure that they've sealed it on the premise that the establishment is run on 2 building blocks. So perhaps the understanding is that for each of the blocks, I need independent licensing. Now, going by 180, my lord, it appears that it is person specific. I mean, so long as it's the same establishment, my lord, I perhaps may not require a separate license for a
There are
separate,
two building blocks. How far apart are they?
inside the same premises. Inside the same premises. In fact, that was subsequently done, my lord.
No, where is the impugned order?
There's
Sealing
no, it was done simultaneously on the
on 2110.
21 day. That's correct.
And where is your trade license?
Trade license, your lordship finds at page 41 and 45 is the renewal. Now, after they suggested, after they contended that we require a separate license, that also we got on the very same day, on 21/10/2024, I'm sorry. So we have 2 licenses as on date.
Okay, where is that? Where-
46 is the first license, my lord, which is valid till 31/3/25, page 46, annexure 9, my lord.
Where, 30, valid up to 31/6. Then,
My lord, at page 48, your lordship will find annexure 10 on the very day of show cause and sealing. We applied online and we procured another trade license.
where is the number? How do we know they are different?
My lord,
License
with,
number, okay, license number.
582
46
and
and
705. And the date also your lordship finds 21/10/20. Now, my lord, all the dairy products are there, my lord. They have a very short shelf life.
Yes, Mr. Nayak, what to do?
If page number 46 is in subsisting license lordship,
And what is the requirement of renewing the same for at least 48 also?
No, because what he's saying is that there are two, it's apparently on two blocks or two shops.
That is not the reason shown in the so-called law. So-called simply says you are not having trade license.
But he has got,
No, on the notice dated 21/10. On the same day, he applied online.
but on page 46 shows that
That
he
is
has,
what I am trying to show, Lordship. If page 46 is the subsisting license,
yeah,
Lordship, then what is the requirement of renewing the same at page 48, Lordship, on the same day? Of
not a renewal, it's a separate license. It's a separate license.
It's a for godown.
Huh? It's a separate license. It's got a separate number,
The number may be different, Lordship. The Lordship may kindly see the business type,
business type.
second line. It's for godown.
Go down.
Earlier one is Lordship for sale and
Sales and
marketing.
marketing office.
Lordship. So for the purpose of godown also, one license is required. For the purpose of sale, another license is there that is accepted. But for the purpose of running, for the purpose of continuing with the godown facility law, this license was obtained only on 21st/10.
But let us see your notice. What does your notice require? What is the allegation in your notice at page 29?
Page 29, Lordship, translated version is given at, yes, page 29. As per you were directed to submit in writing to the undersigned within 7 days of receipt of notice, your reason why you should not take proper action for your Amul business ownership, appropriate action will not be. No,
Now,
in the SMS portion, Lordship, it
Yes.
is clearly written, Lordship, it states without taking any trade license and without renewing any trade license. That is the reason given.
but trade license is got. Now, there's nothing with regard to go down or sales or anything. No differentiation has been made in the notice.
In the notice, no.
Then what will he reply? And then another
But
thing,
he has submitted reply.
he has submitted, but another thing, he said that on the day the notice was issued, the premises were sealed.
That date is not here, Lord. It is only submission, Lord.
It is not, let us see the averment, where have you ever?
Paragraph 12, your lordship will find about the two blocks. Paragraph 20.
No, where have you said that the premises were sealed on the day notice was issued?
I've said that. Paragraph 2, if your lordship takes up.
Yes,
Somewhere in the middle, the officials of respondent number 1 overreach their authority and without giving an opportunity to be heard to the petitioner or respond to the impugned show cause notice dated so and so, seal the building block of the petitioner. on so and so.
when was the sealing done?
Sealing was also done on 21/10.
Where have you said that categorically? There's nothing here categorically. That's only your submission.
Your lordship will find at page 18. Para 18, I'm sorry. Page 12.
Yes,
On 21/10/24, the officials of the respondent number 1
okay.
visited the premises at so and so.
And seal one of the building blocks, not
Correct.
two.
Seal one. Seal one. That's what I'm.
So seal the one where the go down is located, or seal the one where you're having
Go
a
down,
sale?
go down.
The go down was sealed.
Yeah.
So you did not have a,
Page 43, That's the subsisting license, my lord, which is again, my lord, I have a CNF agent. Now CNF agent also has a trade license. And that your trade license at page 43, your lordship will find, go down.
Anyway, since he has got a license now, let him operate.
Yeah.
For the time.
Some issues there, Lordship.
Huh?
Subsequent there to, after renewal of the license, Lordship, now the authority, as it was an online renewal, Lordship. The authority is checking the particulars, Lordship. Today morning also they have informed me that we are going through the submission made by the petitioners, that is the written submission. And we are also in the process, how much money they require.
That is a different thing. That will take, that let it continue, but let the premises be desealed.
Lordship, in that case, Lordship will take up this matter day after tomorrow, Lordship, in the
No,
meantime.
why? These are milk products. Milk products will, they will be, they'll subject to decay. It's not, you see, if it was, I can understand if it was some other sweets or something that can have a long shelf life. But if it's a milk product, then it will all
But
go.
in the written submission, no mention that some milk products are in the
No,
godown.
that is what he has said.
That is subsequent
No.
mentions in the petition only.
He has said it, at least it's there in the
Page
synopsis.
13, Lordship, some paragraph 13, some mentions are there, page 53, Lordship,
Page 13.
page 52.
Wait. Where have you mentioned regarding your milk and milk products?
Page 18, ground dash.
Page 18.
Ground dash.
In the written submission also, that statement is there.
Well, our products worth 68 to 70 lakhs are
Ah,
still lying.
okay, right. Heard Mr.
Exactly.
B.D. Dekha, learned counsel for the petitioner, who submits that the petitioner is running a business which deals in milk and milk products from leased premises situated at NH 37, Lalungaon, Lokra, with the approximate value of 60 to 70 lakhs. The petitioner's case is that the respondent authorities on 21/10/2024 had visited the premises of the petitioner and issued a show cause notice dated 21/10/2024. Stating that his business had been conducted without obtaining the required licenses,
Trade license.
trade licenses, as per the GMC Act, 1971. So, though the petitioner had been given 7 days time to reply to the show cause notice, the respondent authorities sealed one of the two premises of the petitioners with the, on 21/10/2024 itself. The petitioner's counsel submits that the petitioner has been selling his goods in two building blocks under one trade license for sale and marketing office, which had been issued on 1/5/2024 and was valid up to 31/3/2025. He submits that on the day one of the two building blocks of the petitioner's business premises was sealed, the petitioner obtained another license dated 21/10/2024 for godown, which was valid up to 31/3/2025. He submits that the impugn show cause notice should be set aside. And the premises of the petitioner. Business enterprise should be. DC. First up, next paragraph. Issue notice returnable in 2 weeks. Mr. P. Nayak accept notice on behalf of
All the rest.
all the respondents.
One issue will remain, Lordship, on
Yeah.
23rd. Lordship, one order was passed by the GMC authority and it was written to the CNF agent, Lordship. And according to them, Lordship, the building that has been sealed, Lordship, it belongs to the CNF agent, not of the Gujarat Milk Market.
Anyway, those things you take, but this is only for,
Only,
only for de-sealing for that goods not to be destroyed, that's all. And he should be allowed to take it out. That's it.
the Lordship will observe that, Lordship, if some perishable goods are there, Lordship, they may be allowed to take
Yes,
it.
he can take out all the.
The building will remain under seal,
Huh?
Lordship. The building will remain under seal.
But he has to continue his business.
No.
You, whatever penalty has to be.
No, one
you-
is the producer, Lordship, and the second one is the CNF agent. So
Anyway,
as per my
that,
record,
you
Lordship,
see, at the end of the day, your main intention is to obtain some penalty, that's all.
Yes.
You obtain that, that's a different issue. That's a different issue. Because now as on date, been given a trade license, rightly or wrong. Whether who is to be given the trade
trade
license,
license have been given to the petitioner,
Huh?
Lordship. Trade license have been given to the
correct,
petitioner.
correct,
But the CNF building that has been sealed, it belongs to the CNF.
maybe,
He is
maybe.
not the petitioner, Lordship. That is what I'm trying.
No, no. It doesn't have to be that just because he is occupying somebody else's building, does not mean that it is not his
No,
building.
building belongs to others. He is the producer, Gujarat Milk Marketing Federation, and the other one is the CNF agent who continues the business.
He is not the business, he's doing the business. What, who's doing
He
the
is the
business?
producer.
Malad,
Gujarat
We,
Milk
we will see all that later on. That is not the issue. At the end of the day, basically what you want is the
penalty.
penalty only. Right, where are we? Mustafa, he submits that a perusal of the 2 trade licenses that have been annexed to the writ petition would show that one is for sales and marketing and the other is for a go down. He submits that when one of the building blocks had been used by the petitioner for a go down, the petitioner did not have a trade license for having a go down at the time of de-sealing, or the time of sealing of the said building block. Next paragraph. On considering the fact that the petitioner has now been provided a trade license for a go down on 21/10/2024. And in view of the fact that the petitioner has perishable goods in his go down, the respondent authorities are directed to DC the go down of the petition. This is the matter after 2 weeks to enable the respondent's counsel to obtain instructions and file affidavit if necessary.
Next. Item 6.
When is this? When are these cases fixed? 29/6, huh? 12/11. So we'll fix up 12/11. Huh?
Only similar, I have an next one, page number 36. I'm the highest bidder.
You're the highest bidder. You have been settled also.
Yes, and now my lord, earlier I see, this is now allowed. to continue.
Okay, heard, Mr.
Dig a hole.
D. Over. Now, counsel for the petitioner submits that the petitioner had been settled with the Moria Bari
Daily market.
Moira Bari Daily Market. White settlement letter dated 26/6/2024. In person to NIT dated 29/5/2022. He submits that in view of the impugn notification dated 29/6/2024 issued by the respondent, the NIT has been cancelled?
Yes.
The NIT has been cancelled. The NIT and settlement letter have been cancelled. And the earlier settlement holder has been allowed to operate the market till a new NIT is finalized by the state government. Next paragraph. Mr. S. Datta appearing for the PNRD departments that similar matters have been listed on 12. 12, huh? Next paragraph. On considering the fact that the settlement of the market had already been made in favor of the petitioner and keeping in view section 105 bracket 1 of the Assam Panchayat Act, 1994. The state respondents are directed not to ensure that the operation of the market is not that the market is not operated by the respondent number 6. From immediate from today, from today, from when? From today.
From my lord, maybe they already deposited his case money, my lord, for this month. Right.
Okay. From today's what date?
Today is
4th.
4th.
This whole month is from today, provided the respondent number 6 has not deposited the kiss money. Full stop. Even if the respondent number 6 has been deposited the kiss money, the state respondent shall ensure that the respondent number 6 is not allowed to operate the market beyond 30/11/2024. Okay. List the matter on 12.
My lord, as the matter is listed on 12, my lord, Dusty maybe he can serve, my lord.
Okay, yes. Before that, we like Mr. Issue notice returnable in 1 week. 1 week, huh? 1 week. Mr. S. Datta accept notice on behalf of the PNRD department.
1,
While
2,
we-
4 and 5.
1, 2, 4, and 5. While Mr. S.R. Barwa accepts notice on behalf of
Number 3.
respondent number 3. Petitioner to take Dusty's service, to take steps for service of notice upon the respondent number 6 by Dusty's service within 5 days. 5 days and to file affidavit of service thereafter. This is the matter on 12.
Hello,
1994.
To the order, my lord, the earlier order case was, my lord, the prayer for repairing the shed, my lord, that was allowed, my lord. There is no connection with the present petition, my lord.
Mr. Counsel, when was your evacuation done? When was the eviction order passed?
Yes, my lord, page, page number 23, my lord,
Page number 23.
23.
Page number 23. So the eviction order that you have challenged in another writ petition is of July 2020.
Yes,
And when you came to this court in
Yes.
another writ petition
yes, my lord.
in 2021,
Yes.
it appears that you have not mentioned this. Otherwise, I don't think this would have been allowed.
My lord, then I have.
Yeah, you have to. No, I think I'll have to dismiss your
No,
thing
no,
with
then I
cost
have
after
to- I
calling
have-
all the records.
I have not the petition with me, my lord. Then the-
No. You see, you have challenged your eviction notice
Yes,
of
yes.
2020
Yes.
in one writ petition
Yes.
filed in 2020.
Yes,
Then you came to this court in another writ petition
yes.
in 2021
yes, For repairing, my lord.
for repairing the
Yes.
thing. Was there a stay order issued in the earlier 2020 writ petition?
Yes, my lord, yes, I have annexed, my lord.
Writ petition.
Yes, my lord, page number 24, my lord.
So you have been running it.
Yes, my lord.
So you
yes.
have been running it
Yes, my lord. Interim
till
order,
now.
interim order.
So 5 years have gone.
Yes, my lord.
So your earlier writ petition has become infructuous.
No,
Yeah, so 5 years.
My
5
lord,
years.
that is not decided, my lord. That
No,
they have not
there
filed-
is no question. Well, we'll take up all the matters together.
Yes, my lord. Yes.
List this matter
Yes.
along with
2980.
WPC 2980 2020
Yes.
and WPC 85 2021. Full stop. Next para you write. 85. The matter pertains to. No, this writ petition has been filed.
It's paper, sir.
for a direction to be issued to the respondent to renew the petitioner's lease dated 29/4/2016 for BHIT number 17, BHIT, at Nutan Bazar under Narsinghpur Anchalik Panchayat, Kachar district. Gustav. Next para. The petitioner had been given a 5-year lease for bit number 17 in Nutan Bazar, while order dated 29/4/2016. The condition number 6 of the order states as follows, page 13, number 6, okay, number 6. Next para. Where is the eviction order? Page.
Page number 23, my lord.
The petitioner had been given a letter dated 6/7/2020 directing her to vacate the illegally occupied land at Natun Bazar within 3 days. As the petitioner's prayer petition dated 26/6/2020 had been rejected. The letter dated, next part, the letter dated 6/7/2020 was put to challenge in WPC 2980/2020. And this court, by interim order dated 7/8/2020, had directed the state respondents not to disturb possession of the petitioner in respect of bid number 70. Until further orders. Next paragraph. The petitioner has apparently, no, don't put this. The petitioner's counsel submits that the present writ petition is for a direction to be issued to the state respondents to renew the lease dated 29/4/2016. Issued to the petition in respect of bid number 70 at Nutan Bazar. Mr. S. Data, learned counsel for the PNRD department, submits that the petitioner has been in occupation of the bid number 17 for more than 8 years in view of the stay order issued by this court. Further, the petitioner has been hiding facts in as much as he had approached this court by way of WPC 85 of 2021, which was disposed of on 12/1/2021, by allowing the petitioner to reconstruct no, to construct slash renovate the structure on bid number 70. Next para. On considering the submissions made by the parties, this 4 is of the view that WPC 2980 of 2020 and the disposed of WPC 85 of 2021 should be listed together. Accordingly, a registry to list all these matters together on when?
Monday, man.
Monday.
I'm being added to.
But in this matter, there are some subsequent developments. We are in the process of filing an additional affidavit. Let it come up next Monday, or in the meantime, that can also be brought on record. And we might have to file a fresh petition also.
So you have not been granted that petrol, I think. You're not
No.
being given.
That is what we have placed on record. We
I think,
deposited some money that has been adjusted against the penalty. So this is in clear violation of your lordship's order. That is what we have brought on record.
That instruction was not on my part, my lord. I just came to know when you filed the affidavit. So let me also seek the instruction, let the matter come on Monday. Why it was done?
You filed your affidavit also?
My-
Okay. Right, Mr. I. Chowdhury, Learned Senior Counsel submits that due to new development, he would like to file an additional affidavit. First up. On the other hand, Mr. P. Bhardwaj, for the respondent submits that the petitioner's representation dated 17/20/2024 has been rejected by letter dated 2/11/2020. He also seeks time to file. No, he also seeks time to appeal for the instruction. List the matter on.
Next Monday, 11th. Interim,
It was.
that limited, that they will make this applies. On payment.
Not with regard to these new facts. It appears that there is some fraud played.
No, that is what we are bringing on record. We'll place all that. Till then, at least that protection. Otherwise, I'll be on the streets. As it is, they have imposed the penalty of 1.5 crores on top of that.
Anyway, you're not selling right now.
That
Yeah,
I cannot, if they don't make this apply.
But then the problem is now with this new document that they have produced, it appears that you
Yeah.
have committed a fraud.
That is what we are,
No, we'll see on the next day. If
Alright.
it will extend it. Not it.
Supplementary motion, item 18.
Praying for a Passover matter after some time. In fact, he was here, he had to rush to another. After some.
Item 7 for admission.
This is matter relating to rejection of the claim for capital investment subsidy. Lordship, in 2007, the industrial policy was announced, which you lordship find in page 31.
Yes.
You lordship find that there the page 37 minute. Substantial expansion. Close 3 minute. D. Substantial expansion means increase in the value of fixed capital investment in plant and machinery of an industry rate for not less than 25% for the purpose of expansion of the capacity, modernization and diversification. So for substantial expansion, the requirement was that there must be an increase in the value of the fixed capital investment in plant and machinery for not less than 25%. Now, my lord, under this policy, the petitioners were also, there was also entitlement for capital investment subsidy. And accordingly, scheme was framed, my lord. Which you'll also find at page 36. You'll also find at page 36, clause 3. Unless otherwise specified, all new industry units as well as existing units which go for substantial expansion and are located anywhere in NER will be eligible for capital investment subsidy under the scheme. So both new units, my lord, as well as the existing units undertaking substantial expansion were entitled to the benefits of the capital investment subsidy scheme. Page 37 below, the substantial expansion is the same, 25% increase in the capital investment, plant and machinery. My lord. My lord, the petition undertook substantial expansion in the industrial unit, and according to page 46, you'll also find the petitioner submitted its claim for the capital investment subsidy. Now, my lord, the general manager, District Industry Center, forwarded the claim of the petitioner to the subsidy to the Commissioner Industry and Commerce, which is page, my lord, 78. After that, a field visit was made and a report was submitted, which you'll also find at page 80. And also find it page 86. After field verification, my lord, the capital investment subsidy of 3 crores 44 lakhs and what, my lord, that was recommended. That page 92, my lord. No, prior to that, my lord, in the minus of meeting at page 88. Look, the State Labor Committee directed the director IIT to make a visit.
Where?
You know, at page, it is page 88. Element part at page 91. The last part, Lord. The committee discussed threadbare regarding the modernization of the existing industry unit of so and so. The committee suggested the 3 years period prior to the modernization, production quantity with the value should be ascertained from the excise and VAT department submitted by the unit during these periods, it was also decided that the IIT Guwahati should consider so and so. So they wanted to say that prior to modernization, what was the production in the industry unit prior to 3 years? Which was not a condition at all for the purpose of the grant of the capital investment subsidy. For the purpose of capital investment subsidy, the only condition was that 25% increase in the investment in the plant and machinery.
Then
Then at page 92 under the IIT submitted report, that the increase was 19.03%. Then the petitioner may not by different letters at page 99, 100 and 101 requested for the early release of the capital investment subsidy,
page,
99, 100 and 101.
yes,
Thereafter, also you can see at page 103, the additional director commissioner of industry and commerce addressed a letter to the general manager district industry and commerce center, Milot, which said, Milot, with reference to the above, I would like to inform that as per the decision of the 43rd State Level Committee held on so and so, a report was obtained from IIT Guwahati regarding the details of the production of VAT excise return as submitted by the industry unit, namely so and so, on for 30% CCIS under so and so, and the same was placed before the said SLC in the meeting held on so and so. But as per the discussion SLC, the committee suggested to obtain additional information, power consumption, IT return, etc. under modernization. The report is also required whether unit make more production with less cost after modernization, the copy of so and so and so and so. So it was directed not to obtain further information. Page 105 Milot, whatever information was required, that was submitted by the petitioner. The page 107 Milot, in the 50th meeting of the state level committee, classifying for number 2, page 107,
yes,
the claim of the petitioner was considered, and at page 108 Milot. Classifying the second paragraph. The members of the committee had scrutinized the additional information of the unit, that is turnover, production, quantity, employment, power consumed, cost of production, profit of the 2 years and 2 years after modernization of the unit, and observed that the percentage decrease in the turnover, production, quantity, consumed, cost of production, etc. for 1 year after expansion to 1 year prior production was not satisfactory. After threadbare discussion, the committee has decided to reject the claim. Only submission that me for your lordship, neither in the policy nor in the capital investment subsidy, any such condition
Yes,
is there of the increase in production, etc. The only requirement was that an increase in the investment of not less than 25%.
no condition is there for increase in production in the, what, in the
Neither
in the scheme,
policy nor capital investment subsidy scheme,
in the industrial policy.
policy as well as capital investment subsidy scheme.
Capital investment,
Capital, central capital investment subsidy scheme.
central investment and capital subsidy scheme.
Well, central capital investment subsidy scheme. Two thousand seven. Now, these factors which have been taken into consideration are in fact not the factors at all which could be taken into consideration for the purpose of grant of the central capital investment subsidy. In fact, my lord, under the Assam industrial policy, when the VAT remission was there, then such conditions were put in the remission scheme that the production must be increased by this percentage, that percentage. But these conditions being not there in the scheme at the policy at all, my lord, the grounds on which the claim has been rejected are the external ground, my lord, which could not be taken into consideration for the purpose of, my lord, the grant of capital investment subsidy. In fact, the only factor they have to examine is whether, my lord, the investment was more than 25% or not, and that was on the field report. After examination, that was recommended. That what was the investment and what was the eligibility. After that, my lord, the committee has gone into the factors which are not genuine for the purpose of determination of the claim of the capital investment subsidy.
So that's a basic case.
No,
Anything
this is
else? Anything else?
Nothing.
Yes, Lordship, I mean, this is correct that there was no such conditions are there, neither in the policy nor in the scheme. In fact, Lordship, similar matters were agitated before this honorable court. And in a similar matter, Lordship, the rejection was similar on the ground that, I mean, what was the percentage of production increase, what was the electricity consumption, and all these, the same grounds, it was rejected earlier. So what has happened is some three petitioners, three applicants, in fact, they have written to the central government for reconsideration of their matters because those things were not there in the policy. The central government has communicated to the state government that we should, SLC should reconsider those matters. So accordingly, lots of the similar matters were disposed of, and like SLC, those matters were placed before the SLC and SLC took a decision. So in this matter also, lots of same order can go. They're stating that this matter can go back to the SLC and SLC will reconsider this matter in view of the central government's communication. That is
Which order? No, but what is the issue here?
It's the same issue, Lordship. It was substantial expansion. After substantial expansion, it was rejected.
Again,
the
the
same
same.
ground, stating that VAT hasn't been increased, then like excise duty was not increased, then consumption.
So out here, these persons' claims were rejected on the ground of the no data being available with regard to the increase in production.
No, initially it was not, but later on that IIT that report has also come and like other documents were also given, but rejection ground was that it has not increased. So that was not there because that central
So
government later
same ground.
same ground, Lordship, same.
Only that in the judgment you'll also find It appears that the COVID-19.
COVID-19.
It hasn't come properly, Lordship. Factual,
No,
but
I-
they
I
were same
can
issue.
understand.
This is,
I can fully understand. In this case, since it has been rejected, the claim has been rejected on the ground that, the production has not increased. And I demonstrated for lordship, this cannot be a ground at all for the purpose of rejection of the claim of the capital investment subsidy. If your lordship observes, on the basis of that, because my learned friend has also admitted that this cannot be ground, central government is there. Unless until that observation is there, the matter will go and they will say that this is COVID-19.
No, I cannot make any observation.
About the merit, your lordship has 2 minutes.
I can only record your submission.
Unless until.
Otherwise, if I am going to decide the matter, what's the point of sending it to
Well,
the?
then,
to the-
I'm showing to your lordship that the order is illegal because of the fact that, this is not the condition at all.
No,
Submission.
because this substantial expansion,
My lord.
the definition given might be capable of being enlarged. We'll have to go into
By,
those.
by,
aspects.
last by whom?
We'll have to see, we'll have to interpret.
Lordship, see, that the policy.
It says capital investment in plant and machinery of an industrial unit by not less than 25%
My lord,
for the purpose of expansion of capacity.
my lord.
So there has to be, supposing you have capacity was for production of, say, 100 meters of cloth every year. If it is another 25% increase in the capacity, it would mean the capacity to manufacture an additional 25 meters.
That has increased,
So-
the report is there.
No. So that is with regard to production again.
The production, capacity increase does not mean that the production has to be increased. The capacity has been increased. The production does not mean that my capacity is 200. Now that doesn't mean that I must produce 200.
Correct. Now, how do we know that? How do we know whether your production capacity has increased by
That is a report
25%?
Submitted by them. The report is there.
Where?
Yes, I'm showing you, lordship, see the report. Page. Lordship, see page 80.
Yes.
At page 83, lordship, see.
Yes.
Cold rolling unit, bill. Now,
Where?
number 2, 83B.
Yes.
Capacity installed and capacity was so and so. Three strips work with 1400 days per annum. During the modernization expansion in the unit after pipeline and so mill stood and pressing capacity by using robuster has raised and speedy increase from earlier 500 minutes to 800 per hour per minute.
No. No, this is only with regard to the speed.
Capacity, is the capacity.
Installed capacity,
My lord,
installed annual capacity was 59076 metric tons.
my lord.
Now, where is this additional 25%?
25% is sales, my lord. After modernization, it has increased.
Where?
My lord, see. At page 84,
Yes.
the unit produced so and so metric ton in so and so years, 52,000 so and so against the installed capacity of 59,076 metric ton. The unit could improve the capacity utilization and the last year and could achieve 88.60%, which is appreciable.
No, that does not prove anything.
Well, the-
You have got to show me, you see, when the installed capacity is 59,000 076.
My lord,
25% of 59,076 will be amounted to another 15,000 empty.
but.
So you have got to show me.
My lord, if your lordship.
That is how I understand.
If your lordship is going to, your lordship had to observe, my lord, may I observe that if the capacity utilization, if they find that capacity utilization has increased by 25%, they should give it. Let them find out. Other factors cannot be taken into consideration, my lord.
No. So you see, this is what I can understand from a reading of 4D.
My lord.
Because it says here expansion of capacity. Now capacity, if it is 59,000 metric tons, say 60,000. So that means
20,000
25%, another 15,000.
15,000.
So it comes to 75,000.
If the petitioner is not fulfilling that condition, they will not be entitled.
No, because there's another aspect. Then it says / modernization. Now, what is this modernization? I do not know.
Well, modernization also may not, because earlier as a lordship matter came out for lordship. Confusion was that what is the expansion, what is the modernization? Now, modernization also, the question is that the capacity utilization. That's why our case is not expansion. So when our case is expansion, if the petitioner is fulfilling that criteria, other factors cannot be taken into consideration.
No, maybe. But I have to be satisfied with this.
So let them
Or-
verify,
or-
let them verify.
So let them do it. Let them take the
But
decision.
at least that action must be there, whether they must do the exercise to find out whether I am fulfilling 4D or not. If I am fulfilling 4D, they should be granted.
Correct.
So that may be objection, my lord. I don't say that you lost me direct.
4D in whatever, however they consider it fit because they are the experts. We do not know.
I don't say, my lord, your 4D fulfillment, other considerations should not be there, my lord. Other than 4D.
You see, I do not know specifically whether that production, the issue of production cannot come under 4D or not. It might come under 4D. I do not know. This is,
My lord, my another friend has himself admitted, my lord, that 4D, the production will not come. And
I do not know. He is neither an expert or such.
My lord, you lost me only.
If he can give me in affidavit that, then it's okay. Then I can, if he can give me by way of an affidavit that production does not come under 4D,
My lord, you
then
lost-
I will take a decision.
You lost me, see 4D, plain reading of 4D, my lord. You lost me, find the question of production is not there.
No, production, when you say capacity includes production.
My lord,
Because without production, you cannot reach that capacity.
No, my lord, capacity, I may increase the capacity to 100.
Okay,
My lord, when the my lord, power load is taken,
correct,
the installed power load is 50 kilowatt. But utilization may be 25.
correct.
So
That I'm
here-
not on that.
So here, my lord, the installed capacity has to increase.
Correct,
It doesn't mean, my lord, that the production must be there,
correct. That is one aspect.
my lord. So installed capacity has to be seen whether it has increased or not.
Correct,
So if I increase the installed capacity by 25%, I'm entitled to.
correct.
So that's why I'm saying, my lord, that I must fulfill the 4D criteria. So if you also may object, the 4D criteria
The lordship.
is
sorry.
fulfilled.
So the production is not important.
Because that's-
Yes, correct. I understand. If the capacity is such, if they don't know, even if they don't produce, even if they produce less,
My lord,
as long as the capacity reaches that 25%, that is enough.
My lord.
Only thing now, what about modernization? What is this
No, I'm not
modernization?
saying the modernization in the case. This is not the case at all.
Lordship may kindly, everything will be clear. Lordship may kindly come to page 32 once.
32.
32. It explains what is substantial expansion. So Lordship has gone through it. Lordship, I'll just read out. It's about the investment of money, the capital investment. So Lordship will see, I'll just read out. Incentives on substantial expansion will be given to units affecting an increase by not less than 25% the value of fixed capital investment. So increase has to be in terms of the fixed capital investment. Fixed capital investment in plant and machinery for the purpose of expansion, capacity, stroke modernization and diversification as against an increase of so-and-so in prescribed so-and-so. So it's Lordship, if somebody invests 25%, what was the original capital amount is there. In addition to that, if he invests 25% more of that capital investment, that will be capacity enhancement.
No,
So that
that,
is what-
you see, that investment has to be towards a certain objective.
Correct.
It cannot be just that,
No, that's true.
since I've built one, the building structure is
Correct.
1 crore.
Plant and machinery.
In plant and machinery also. So actually it is the
Anyway,
amount.
let it be decided as per
Yes,
this.
Lordship, we are actually,
4D
Lordship,
only.
the similar issues were agitated before this court, and like central government had instructed that you should reconsider.
So, my lord,
those things.
only 4D conditions on the basis that they will decide.
Actually,
Not other conditions other than 4D.
Right. Heard Dr. A. Sharaf, learned counsel for the petitioner, assisted by Mr. P.K. Bora. Also heard Mr. A. Kalita, learned counsel for the,
Yes, so not two, 3 and 4.
which was number 2, 3, and 4. Mr. S. S. Roy appears for spot number 1. The petitioner is aggrieved by the rejection of the petitioner's claim for grant of 25% subsidy in terms of the Northeast Industrial
And investment policy.
and Investment Promotion Policy, bracket NEIIPP, bracket close, comma 2007. And the Central Capital Investment Subsidy Scheme, comma 2007. To stop. Next para. The petitioner's counsel submits that the petitioner had made substantial expansion in terms of clause Roman 4, small, of the NEIPP 2007 and clause 4 bracket D of the notification dated 27/7/2007 with regard to, in relation to the Central Capital Investment Subsidy Scheme, comma 2007, hereinafter referred to as the 2007. The petitioner's counsel submits that the petitioner had made a claim for grant of 25%, 25% subsidy in terms of the above schemes, policy and scheme on 10/3/2016, which was forwarded to the concerned authorities by the General Manager, District Industries and Commerce Center, Kamrup M. Guwahati, on 10/6/2016. A report on the claim for subsidy made by the petitioner was made by whom? By what committee?
This is a committee constituted by the
What is the name of the committee?
name.
By a committee constituted by the government of Assam,
By the Commissioners Industry
by the government of Assam,
Industry Department.
Industries and Commerce Department. Which stated that the field visit team had recommended that the petitioner
30.
should be given
It was
subsidy at the rate of 30%,
instead of 25% to 30%.
30%, 30%, 30, earlier also, instead of 25, it should be 30. At 30% of the scheme, at 30% of the claims under the CCIS 2007 and NEIPP 2007, that is rupees 3,44,01,12.
Instead of 30% of the claim, 30% of the investment. 30% of the investment.
30% of the investment, huh? 30% of the interest.
Well-
The earlier 25% is correct. 30% of the investment, okay? I wanted to separate, next part. Next para. Thereafter, no, to continue, thereafter, in terms of the 43rd meeting minutes of the state level committee for central capital investment subsidy under NEIPP 2007 held on 9/5/2017, 9/5/2017. The it was resolved that the IIT Guwahati should be requested to access production and productivity increase 3 years prior to and 3 years post the modernization / expansion of the petitioner's unit. Consequent to the 43rd meeting minutes of the state level committee held on 9/5/2017. The Dr. P.S. Robi, ROBI, Professor, Department of Mechanical Engineering, Indian Institute of Technology, Guwahati, submitted a letter to the Commission on Industries, to the Commission of Industries and Commerce, stating that he was deputed to access the productivity and production increase due to modernization program carried out by the petitioner. And on inspection, he found that the productivity increased, leading to an increase in annual production of the plant by 9359-16 MT, that is an increase of 19.03%. The petitioner's counsel submits that the petitioner thereafter submitted various representations for release of subsidy. However, the Government of Assam Office of the Commissioner of Industries and Commerce thereafter issued a letter to the General Manager, District Industries and Commerce Center, Kamrup M, stating that as per the decision of the SLC held on 9/5/2017, the committee had suggested obtaining additional information regarding power consumption, IT return, etc. under modernization. Yes, sir. The petitioner thereafter supplied additional information to the respondent for grant of the 30% CCIS claim. 30%,
30%,
not 25.
25% increase in production.
30%. Good stuff. Next part. Thereafter, in the 50th meeting minutes of the state level committee for the Central Capital Investment Subsidy under NEIIPP 2007 held on 30/10/2018, the committee took a decision that the additional information of the petitioner's unit regarding turnover, production quantity, employment, power consumed, cost of production, profit, etc. 2 years prior and 2 years after modernization of the unit. Besides observing the percentage of increase/decrease of turnover, production quantity, unit consumed, cost of production, etc. of 1 year after expansion and 1 year prior to expansion, were not satisfactory. Page 108, second paragraph. The petitioner's counsel submits that the rejection of the petitioner's claim for subsidy on the basis of the turnover/production quantity, power consumed, etc., as reflected in the 50th meeting minutes of the state level committee for Central Capital Investment Subsidy under the NEIPP 2007 held on 30/10/2018 should be set aside in view of the fact that the grant of subsidy in terms of the 2007 scheme and the NEIPP 2007 could only be relatable to clause 4 of the NEIPP 2007 and clause 4D of the 2007 scheme. So he submits that the question of going into the production of the materials power consumed, cost of production, profit, etc. cannot be a ground for deciding whether the petitioner is to be granted subsidy, as the same is not provided in the meaning of substantial expansion. The respondents would only have to consider would have to consider the petitioner's case only on the basis of the definition given to substantial expansion as provided in the NEIPP 2007 and the CCIS 2007. Next paragraph. Mr. A. Kalita, learned counsel for the respondent. Respondent number 234. 234 submits that this court had disposed of similar cases, that is WPC 443/2019, 435/2019, and only these two. By directing that the claim of the petitioner should be placed before the next state level committee meeting to be considered in the light of instructions issued by letter dated 17/6/2022 by whom?
Undersecretary to the
By
government.
the Under Secretary to the Government of India, Ministry of Commerce and Industries. Huh? You said by the sense of by letter dated. On considering the submissions of the council for the parties and keeping in view the disposal of WPC 443/2019, MS Ozone Ayurvedic, Unit Roman 2 versus the state of Assam and 6 others, and WPC number 435/2019, Ozone Pharmaceuticals Limited versus the state of Assam and 6 others. This court is also of the view that the writ petition can be disposed of in the same light, in the same manner. Accordingly, the state respondents, accordingly, the claim of the petitioner shall be placed before the next state level committee meeting to be considered in the light of instructions issued by letter dated 17/6/2022. Issued by the Under Secretary to the Government of India, Ministry of Commerce and Industry. Further, the state level committee shall have to consider the case of the petitioner in terms of the definition of substantial expansion provided in the IPP 2007 and the CCIS 2007 with all its connotations. The writ petition is accordingly disposed.
Words below. Two words below without other extraneous factors below. Otherwise,
No. Let them decide.
then strictly, you can say strictly.
No, I said that with all its connotations, because let them decide. They are the expert. We cannot, we cannot, that can always put to challenge against.
Lordship is not deciding that issue, but at least in terms of the 4D.
I've said that, I've said as per the definition of the, actually, one word, somewhere you can decide. The so-and-so expansion as provided in clause so-and-so of the NAIPP 2007 and CCIS 2007 are reproduced herein below as follows. You just take it. Huh? That is at page, I think, waiter. One is at page. (32) and one is at page 37.
Please.
That is your lordship. Lordship, in this matter, one additional affidavit is required to file in the.
You have got to file some reply affidavit.
No, my lord, the issue is like this, my lord. Now, whether the petitioner is liable to pay forest royalty. But
Correct.
this matter has already been adjudicated not once, twice.
And my lord, there are series of judgments by 5 honorable judges of this honorable court, where this honorable court is held. If the contract does not contain any clause, then they cannot insist. My lord, I fail
No,
to.
no, one thing, why I'm saying this before you go further. On the last day, you had taken time to file reply. RM Deka, the learned counsel appearing on behalf of the petitioner, seeks some time for filing reply against the affidavit in opposition. Last court order. This is here.
My lord,
It is here.
no, that's true, my lord. Now, what I find, I've gone through the file yesterday. It's not that they have brought out anything which requires reply. It's only a question of, my lord, it's already decided matter.
No, maybe, but now you see, I was waiting for your reply. If you all are going to take the stand, then I'll record that you all are not filing any reply.
Okay, my
Yeah,
lord, let the matter be called next week, my lord. We'll file a short effort.
okay. If you want to file, I'm not forcing you to file if you don't want to file.
Lord,
It's your prayer. It's your prayer out here, that's why.
That's a fault. It may say it is open to them to file or not. Let the matter come after a week. We'll decide. We'll take a call on it. But
Okay,
my lord, there is one thing, I think my learned friend, actually, my lord, who is advising the government like this? These are the bunch of judgments on this point. I can say, my lord, writ appeal was also dismissed, filed by the state. Every time, why we have to come? Otherwise, my lord, res judicata makes no sense. It's a public policy. Well, I'm sure some law officer, somebody must be advising the government. That's why the officers have taken this stand.
I don't know.
It's a very serious matter. Otherwise,
Anyway, right. Mr. K. Chaudhary, the learned senior counsel for the petitioner, seeks some time to take a decision as to whether affidavit in reply will be filed or not.
Yes.
He submits that. He submits that if affidavit in reply is to be filed, the same will be filed within 10 days.
1 week.
Within 1 week. Miss
M. Das,
M. Das appearing for the
PWDs,
PWD. We want to file what?
additional affidavit.
Submits that she wants to file additional affidavit.
Today itself.
Today itself.
Hmm.
Okay. Praise the Lord. Leaves the matter after a week.
Yes.
Driving motion ID 20.
Quite feasible. Your Lordship, this is a second round of litigation that has fallen from pursuant to your Lordship's order at page 70. I'll request your Lordship to come to page 70.
Yes.
Yes.
17.
70, Your Lordship, 70. It is annexure number M. I'll give the brief background of the facts, Your Lordship. In fact, Your Lordship has noted the facts in the earlier round of litigation
Okay.
that there was a mining contract, Your Lordship, which was granted in favor of the petitioner by the Forest Department for a period of 7 years. Then the respondent number 2, which is the SEACC, it is empowered to grant an environmental clearance certificate. The environmental clearance certificate, as usual, is granted for a period of 5 years, not 7, 5 years. Thereafter, for the remaining 2 years, the environmental clearance certificate ought to have been renewed. Now, the environmental clearance certificate stipulates a certain mining proportion every year. That proportion having been followed, your Lordship would kindly come to page 53. Page 53. Page 53. This is the order, your Lordship, which was impugned in the first round of litigation. The order dated 3/1/2024.
Okay.
Page 53. Page 53.
Yes.
Yes. Your Lordship has gotten page 53.
Yes.
Yes. So this was the environmental clearance certificate, which after the expiry of the first 5 years was extended for a period of only 6 months, not the remaining 2 years. The reason being, your Lordship will kindly come to page 54. Page 54. The next paragraph.
Yes.
Your Lordship sees resolution by the SEAC
Point number one.
Yes,
Yes. The issue has been deliberated thoroughly. This is the italic part of the first paragraph, Your Lordship. The issue has been deliberated thoroughly. The committee, after due deliberation and considering the recommendation made in the mining plan, deem it appropriate to recommend the proposal for modification, approving to extract sand. The remaining sand would be 2,000 cubic meter and stone 5,000 cubic meter for the proposed mining site within 6 months, the quantity being 2 meter. So the extension, which ought to have been for 2 years, was extended for a period of only 6 months. We drew parity with somebody who was doing the exact same thing. Your Lordship will kindly come to page 59. Page 59.
yes,
Page 59, the quantity of sand and stone to be collected. This is for a similarly situated settler, Your Lordship. The same amount of sand and stone, the entire period of 2 years was granted as a environmental.
maybe in his area there is more quantity
It's the same quantity. The
Huh?
same quantity.
from the same area.
Same adjacent mining area, the same
Adjacent-
quantity, Your Lordship. Same quantity of sand and stone to be mined.
Maybe same quantity to be
It's
mined,
absolutely the same.
but the only thing is that there might be more of that thing here and less here. Everything is not the same.
No,
Somebody might be having 20 kgs of rice in their house. The next door neighbor might be having only 5 kgs. What is it?
so what has happened, Your Lordship?
You cannot just say that just because
No,
you have been allowed to extract the same thing, the
Yes.
same amount, does not mean that in your area
Yes.
and his area, there are similar amount of sand and stone. How do you count?
So what has happened, Your Lordship, is that the clearance which is granted is for assuming that somebody has a larger amount of the quantities to be mined. The clearance is given only for a certain quantity that is to be mined. So the quantity which was to be mined was 7,000 cubic meter of sand and 17,000, that figure. Now, when 5 years were completed, the remaining sum of sand and stone, which ought to have been mined, was as per the initial criteria which was laid down. Now, that 2-year extension was not given, citing that the remaining material was 2 meter. Now, Your Lordship had interfered. Your Lordship interfered, and Your Lordship's order is at page 74. Now, this is the second time we have come here. Page 74. Your Lordship saw the entire parity with somebody who was similarly situated. Paragraph number 8, page 73. Page 73, paragraph number 8. On considering the above facts, this court does not find any justification for limiting the extension of the environmental clearance for only 6 months, while the settlement of the mining contract area with the petitioner remains valid till 31/10/2025. Accordingly, this court is of the view that the respondent number 1 should consider extension of the environmental clearance for the remaining 1.5 years, provided the petitioner submits his application for extension of the same within the period of 2 weeks from today. The respondent number 1 shall thereafter take a decision on the petitioner's representation for extension of the environmental clearance till 31/10/2025 within a period of 1 month. The decision should be taken, communicated to the petitioner. This was Your Lordship's direction in the first round of litigation. Then at page 75, Your Lordship would see we had preferred an extension representation, and thereafter the respondent number 2 had written to us calling us for a scheduled presentation on 9th of August 2024.
Mhm.
Your Lordship kindly sees at page 75, there are few documents which have been sought from the petitioner. 1, 2, 3, 4, 5, 6, and 7. Your Lordship sees that.
Yes.
Yes, page 75.
Yeah.
Pursuant to that, the petitioner performs the presentation. And thereafter, Your Lordship would kindly see page 79 is the order we have impugned. Order we have impugned, page 79.
Yes.
This is the order impugned. At page 80 is the operative part which we are challenging, page 80.
Yes.
The extension of the environmental clearance for a period of 2 years up to 30/10/2025 is not covered by the approved mining plan, which is valid up to 14/5/2025 from the competent authority, is impermissible in view of the above explanations and observations, and therefore the SEAC is of the considered opinion to reject the plea of the proponent who is a beneficiary of the EC not permissible under the extant law. Now, this is a new ground they have taken. What happens in the
And your
process
permit is still valid till?
till 30/10/2025? That contract of the mining contract is for
And 30/10.
30/10/2025
And your extension was valid till?
till 14/5/2025. The reason that happens is because there are stages in which
Huh?
there are stages in which the approvals are granted. Initially, the environmental clearance is granted. Thereafter, the petitioner enters into an agreement with the forest department. The forest department is the agreement with which I have a period of 7 years. These are standard format templates where a 7-period year is granted. Now they've stated that there is a disconnect between my environmental clearance till 14/5/2025 and my agreement expires on 30/10/2025. This year, Lordship has seen is a new ground now they've taken. Now, be as it may, be as it may. Your Lordship will kindly come to page 81. Page 81. Page 81. Now, this is the same individual who was granted another extension lease of environmental clearance of 2 years. This Himanshu Nath, your Lordship sees his environmental clearance, his approved mining plan now is valid for a period of 7 years.
Where do you get that?
Your Lordship sees declaration by the applicant.
Yes.
Yes. This mining plan is prepared on the provision of the Assam Minor Concession so and so. I understand its contents are hereby agreed to implement the extraction work of the sand in accordance with the prevailing provisions of law. If any other permission is needed, I shall approach the authority before commencement of the extraction work. This declaration by the applicant, your Lordship, is for a period of 7 years.
So
Now there is a disconnect. Now, your Lordship has seen that this for a period
let
of
us
7
see
years.
your declaration. Where is yours?
Yes. My declaration, your Lordship, it did not be stated separately because it is stated that it is valid up to 14/5.
14/5.
14/5.
So
It is-
then
it is
someone
not
is
in
wrong.
dispute. It is not in dispute. Now, your Lordship, there is a detailed matter. 7/9/2017, that other individual who is similarly situated, his approved mining plan is for a period of 7 years, which ends at 6/9/2024. Now, your Lordship will kindly, for a moment, come to page 59. Again, page 59. This is the same individual. On 14/2/2023, his environmental clearance is extended by 2 years, notwithstanding the fact that his approved mining plan and the mining contract, there is a certain period of gap. Now, this is a ground which has been belatedly taken by the authorities. The first ground for them was the fact that the amount was too meager. Now, when that did not suffice, now there is a later belated stand taken by the authorities.
So that ground of being too meager.
Yes, now
Now there
is no more a
that
consideration.
is not a
Now
ground.
it's a new ground, and your Lordship would see they have not sought for the approved mining plan by them. The 7 pointers which have been laid down for which I was supposed to present my presentation. The approved mining plan was not there, and if need be, the approved mining plan is granted by the Forest Department. They should have sought for an opinion of the Forest Department. We could have had that renewed for the next 30/10/2020.
You have it renewed from the forest department.
But till then, we'll do that. We'll do that, your Lordship. Absolutely, we'll do that. But the problem that arises now is that since the extension has not been granted to us, the authorities have determined the contract to be not 7 years, but 5 years, just by the way of environmental clearance. Now, there's a possibility that if your Lordship does not protect me, before I get the environmental approved mining plan redone, there's a chance that they might settle it with somebody else. I need your Lordship protection. Your Lordship will grant me some time. The petitioner is going to do the needful.
Who is for the forest? Who gives the environmental protection? Environment clearance.
Clearance.
Even by the state, by authority, they give the clearance of the to extractor.
So there are 2 authorities involved. The Forest Department will have the mining agreement. with-
Anyway, you see, one thing is,
Yes,
just because they have given this Himanshu whatever,
yes,
the extension
yes,
beyond the approved mining plan,
yes.
does not mean that they should continue.
Then my mining plan should have at least continued.
Then in the meantime, you make another one, fresh one to
No,
the forest.
we'll procure whatever your Lordship determines today. But till then, your Lordship will not close the matter. Your Lordship will protect me. That is
Yes,
my only
what is to be
There's
done?
nothing
If the mining plan,
Cannot, since there is no environment clearance, we cannot allow him to go for mining.
Yes.
You have to first obtain the clearance.
then there'll be a mining. No. The mining plan has to be given prior to the environmental clearance or after environmental clearance.
Mining plan, comes, for extraction, the mining plan, which he, is the.
Before or after, that's all. Huh?
Before that.
Before environment, then you give him a new fresh one.
Will give money, but the thing is that until unless you don't get this, the clearance from the environment.
Mister, just now you said that the mining plan has to be approved prior to the environmental clearance being issued, correct? Then why do you want it now the other? Why do you want to put the cart before the horse then? Now what you are saying is he should have the environmental clearance, then we'll give him the mining plan. How is that?
Like is given, like, we cannot expect the. No, okay.
Mr. Council, what is the submission? You're not making sense. On the one hand, you are saying that the mining plan has to be approved prior to the environmental clearance being issued, correct?
Yeah.
So number one is mining plan, number two is environmental
Yeah.
clearance. Now, what are you saying? You're saying he should get this first, then this. Yeah, contradicting yourself.
Once it-
Because his mining plan now has expired, apparently, 14/5.
No, it will expire.
14/5 of?
2025.
Oh, 2025
Yes,
only.
it is expired now.
Oh, it's,
So
14,
based
so
on
it's not
something which
expired
is
now.
going to happen later, that is what they've done. Your lordship sees
Okay.
at page,
Okay.
the impugned order is at page 79, 80 is the operative part. It is valid up to 14/5/2025, and the agreement expires on 30/10/2025. So because there is a 5-month gap in between, which is again only because there is a fixed template.
So it's so the mining plan is still valid. So they could have that authority should have given environmental clearance at least till the validity of the plan.
Still that subject to me furnishing
Yes.
pre-approved plan.
Yeah.
So your lordship will protect me, at least lordship will protect me, because the lordship closes the matter. Now
Ah.
what they're gonna do, the authorities now, this is not a pleaded submission, but the conduct of the authorities now, it indicates that somehow they went on not providing me with the environmental clearance because there's a ground. As per the fact, it was too meager. It was too meager only because I was following a pattern which was set by them.
Okay, anyway, right.
Yes.
Heard
M. Sharma, I got.
Mr. M. Sharma, learned counsel for the petitioner,
Yes, yes.
who submits that. You take this, huh? Page 71, first para. Then para 2 also you take.
Page 71 is a lordship's order.
I know.
Yes, yes.
I'm going to.
Yes, yes, I apologize. I
So
apologize.
I don't have to, go do the same thing.
79, you meant your lordship. I apologize.
Then para 3. The petitioner being agreed by being given environment clearance certificate for only 6 months, despite the petitioner still having 2 years left for mining, for extraction of sand and stones till 31/10/2025, comma. The petitioner approached this court by WPC 1617/2020. This court disposed of WPC 1617/2024 by order dated 24/4/2024. By directing the state, by directing the respondent number, by directing the respondent number, respondent number 2,
Yes, your lordship.
to consider extension of the environmental clearance, petition of the environmental clearance for the remaining 1.5 years, provided the petitioner submitted his application for the same within 2 weeks. Full stop. The petitioner's counsel submits Next para, that the petitioner submitted an application for further extension of his environmental clearance for 1.5 years. In terms of the order dated 24/4/2024, passed in WPC 1617 of 2020. The same was rejected by the respondent number 2, while letter dated 18/10/2024, on the ground that though the petition had applied for environment clearance for a period of 2 years up to 30/10/2024.
Yes.
The petitioner's approved mining plan was valid only up till 14/5/2025. Full stop. Next para. The petitioner's counsel submits that the mining contract, the adjacent mining contract area is being undertaken by one Shri Himanshu Nath, whose mining plan was prepared on 7/9/17. And the 7-year settlement period for the said mining area had expired on 6/9/2020. Despite the same, the respondent number 2 had given Shri Himanshu Nath an extension of 2 years.
Yes.
And had given environment clearance extension for 2 years.
Yes.
That is up till
13/2/2025.
30/2/2020, 30,
1/3/2/2025.
13,
Yes.
1/3/2/2025.
Yes.
That is even beyond the expiry of even beyond the expiry period of the approved mining plan of Shri Himanshu Nath. On the other hand, even as per the logic applied by the respondent number 2, the petitioner's approved mining plan being valid till
14/5.
14/5/2025, the respondent number 2 could not have rejected the petitioner's application for environmental clearance till 14/5/2025. Next, issue notice returnable in 2 weeks or 3 weeks or 2 weeks. 2 weeks.
Response unprotected,
I'll 2 weeks.
Yes.
Mr. R.R. Gogoi accept notice on behalf of 3, 4, 5, and 6. Mr. A.K. Datta. That's point number 1. Anybody else? Next. Petitioner takes step for service of notice upon the respondent number 2 by registered postal AD within 2 days. Stop. In addition to the above, the petitioner shall serve notice upon the respondent number 2 by way of dusty service within 10 days and file affidavit of service thereof. List the matter. Give a date. On considering the submissions made by the counsel for the petitioner. This court is of the view that the petitioner has made a prima facie case has made out a prima facie case for passing an interim order. Accordingly, The respondent authorities are directed not to issue any fresh tender process for settlement of NKD B2 Safa, mining contract area and the North Kamrup division, Rangia, which has been settled with the petitioner for 7 years. Are you working now? Not working, you have stopped.
Yes, stop. Because there's no clearance in account.
No, to stop. That's all.
Just one factual correction, Your Lordship. Himanshu Nath, that clearance was not in 13-2.
Huh?
That clearance, Your Lordship, I had stated 13.
13-2, yes.
It is 29/12/2024.
29/12/2024, okay.
Yes. Great for the Lordship.
No instructions.
We have received the instructions, we'll be filing an affidavit in opposition.
Okay, Mr.
MV, Your Lordship.
For the PWD.
Lords,
Submits that instructions have been received and he'll be filing affidavit within
2 weeks, Lordship.
in 2 weeks. This is the matter of 2 weeks. Give a date.
Obliged.
10 and 11.
The same issue with regard to that substance test, whether prior approval is necessary.
What is to be done now?
Lordship, that issue, my lord, by looking at the my lord, particular clause, whether the prior my lord, approval is at all required. My submission is that all along, my lord, as a procedure, though the my lord, clause does not require my lord, the prior approval, as a my lord, procedure, approval is granted. There's nothing called prior as such. Now here initially,
Where is the clause page?
Lordship, at page 11,
Page 11.
Lordship, my request. I have put it, my lord, extract portion I have given by separate in the edition. of the- Page 11.
Yes, what is to be done?
Lordship, if I may. So before Lordship and Senior Counsel delves further into the matter, Lordship, this matter can it be taken along with item number 19, which is WBC 5212. In that matter, the instructions which we have received, they're not proper. We have asked for proper instructions. If possible, can it come next week?
No, no, that's a totally separate issue. That is when a technical bid was applied. Other than this clause, they have rejected me other grounds. So I have challenged that one, my lord. This is not the issue there. Because this, my lord, they have undertaken before this court in one of this.
So what is to be done? Who is going to argue the matter?
Lordship Counsel B. Gugoi, but currently there is a medical admission matter going on because today is the last day. Tomorrow is the last day for medical admission. Has to be decided today. He is busy in that, Lordship.
So, my lord, because-
No, I know that medical matter will take time, I know.
Will take time.
Because that need PG.
Yes, Lord.
Any short minute, the date minute conveying to the court, my lord, because what is happening, my lord, my other tenders are being also rejected, my lord, recently in the Mizoram also, my lord, that has been rejected, saying that this court has not decided. I have said this court prima facie satisfied with the contention, there is an interim order passed, not to settle the, my lord, not to finalize the contract. So therefore you review, accordingly, they have reviewed and they are waiting for the decision of this court whether to proceed.
Yes, when can we decide?
Short date, Lordship, Lordship will fix it on Wednesday if possible, if there is no problem.
Today is 4th.
Court, Lordship, sixth. Yeah.
This is the matter on the pair of the council for the PW.
Much obliged, Lordship.
Item 12 for orders.
In this case, I pray for 1 week time, Lord, if it is usually full. Lord, fix the matter on 11th, Lord, next Monday, Lord. I have already.
To do what?
Lordship, do the needful, Lordship, it has to be sent to the finance department, Lordship. We need a week time, Lordship, to do that, Lord.
Mr. On the prayer for adjournment made by Mr. N. Upadhyay, who submits that he needs some time for making the payment to the petitioner. Not he needs, the respondents need, huh?
Eight and 10, I am paying for those. As per note 8 and
Respondents number 8 and 10 needs time to make payment to the petitioner. List the matter on, give it.
All right.
11.
Item 14.
On the last occasion, your lordship directed us to take steps for the private respondent, 5 and 6, and Liberty to Dusty also. So he rejected the Dusty and
Where is the affidavit?
the comment over the steps is also not given by the registry.
Huh?
Madam, the registry has not given any comment regarding the. steps.
Naturally, it was issued only on
No,
24/10.
madam, regarding the usual process also, no, it's awaited. Ma'am.
It was done only nearly 10 days back only. Then where is the question?
Regarding the rejection part, I can file an affidavit, madam.
You have to file, otherwise how do we know? That you know better.
Witness was also with me.
Yes.
My lord, I am for respondent paid and I seek further time to file affidavit in opposition.
Who is respondent number 8?
She is the resident of that particular violated premises.
And who are you?
That I am one of the flat owners of that building. I reside
Okay, right. Office note indicates that notice was issued to the respondents number 5 and 6 only on 24/10/2024. Accordingly, await service report. Further, there is no affidavit regarding dusty service notice on the respondents number 5. The petitioner's counsel shall file an affidavit with regard to the service of notice by way of dusty service to the respondents number 5. Mr.
S. Gupta.
Mr. S. Gupta appearing for the respondent number 8 is granted. How much time?
3 weeks time.
Is granted 3 weeks time to file affidavit in opposition. This is the matter. What about you, Mr. S. Bora?
I'm appearing for 3 to 4, I'm also. Section is awaited.
Okay, right. Mr. S. Gupta and Mr. S. Bora, huh? Correspondence number?
3 to 4.
3 and 4. Okay.
Item 13.
Procedural is required to be corrected. That was not corrected
Huh?
earlier.
You have not taken steps?
I am not taking.
You have appearing for whom?
I am appealing for the respondents, 1 and 2.
Which one? 1 and 2 means?
2 is concerned, my lord,
Okay, for the newly pleaded respondent, you are appearing.
No,
Yes.
they have to take steps, Lord. For the
You said 1 and 2 just now.
earlier 1 and 2. So in both the cases,
Earlier, there's only 1.
no,
So where is the earlier 2?
Deputy Commissioner, if Lordship
The deputy commissioner was Mr. Ashim Kumar Bhattacharya. He was respondent number 1. There was only 1.
and SDO Civil is a particular.
Is this civil is a party?
Yes,
in contempt petition number 508, and you see, you know the party, but in the present case,
This is 509.
508. Here in this one, only the deputy commissioner is the party.
Yeah. Since you are appearing for respondent number 2, yes. He is the newly pleaded respondent.
but from the SDO Civil in this case, Lord, I have
There is no SDO civil in this case. What is the Ajit Kumar Prasad?
Ajit Kumar Prasad, but
There is no SDO civil. Is there any SDO civil?
In 509 Malad,
That's
only the
right.
deputy commissioner was the.
the new party, they
New party is the new party is Sri Anand Malhotra, IS,
Yes.
sub-division. Okay, yeah, he's the SDO.
he's the SDO civil.
Correct, correct. The problem is, Mr. Council, you did not submit amended cost title.
Yes, Malad. That
Then?
was wrong committed by me. It will be collected within this 2 days.
And neither have you taken
Stays also.
steps.
Yes,
Then
Malad.
what is your name? Should we dispose of close the content? You're not interested.
Within 2 days, I shall take steps as well as correct the cost structure. Within
When?
2 days. Within 2 days.
Mr.
MK
MK
Sharma.
Sharma submits that he will take, he submits that he will submit the amended cost title and take steps for service on the newly implemented as point number 2. In terms of the order dated 3/10/2024 within 2 days. This is a matter after 5 weeks.
How about you?
5 weeks.
Since Malad, brother has appeared.
He is not appearing for 2. They are appearing for 2.
Now, there are 2 cases, my lord, connected. In the
Are
other
you
case-
appearing for 2?
No, not at this stage. But in the other connected case, I am appearing for the SDO.
There is
civil,
no, there
petitioner.
Huh?
2 cases, they are usually coming together,
did not come together here. It's not it.
not in this.
How about you?
My lord, I have received the instruction, my lord, from the respondent number 3, Chairman, Sonari Municipal Board, my lord. I have received the instruction, my lord. May I pray for 2 weeks time, my lord?
What is the instruction?
Instruction is, my lord, it is about 90% people are other religious people, and my lord, there are Mandir, Kali Mandir, Shiv Mandir, 300 meters, 30 meters, 300 meters, Durga Mandir, 300 meters, Jain Temple, 300 meters, Sani Mandir, 400 meters, Hindu Mandir, Hari Sabha, 320 meters, Namgarh, 800 meters, and Buddha Bihar in 600 meters. And my lord, that is our instruction, my lord. So it's surrounded by more than 90% other religious people, my lord.
So what?
So that's why, my lord, it's and it was on, my lord, the license was, my lord, up to 31/3/2022, my lord. After that, license was not renewed, my lord.
No, no.
License was up to 31/3/2022, my lord. And it was not renewed after that, my lord. And the notice was given on 30th June 2022. That was in the earlier proceeding they have challenged it, but during that time, my lord, already license was expired, my lord. And after that, the act, my lord,
Okay, so the interview notice has been set aside now.
set aside, my lord, and so
Interview notice has been set aside. Only thing is that the license has to be issued.
license has to be issued, and it is up to the authority.
You find an
of the
affidavit.
my-
Ms. Yudas, submit that she has received instructions and will be filing affidavit within 2 weeks. This is a matter of 2 weeks.
16th Senate.
Anything, madam?
No, lordship,
Your name should be this.
yes,
Yes, Miss
Bidas.
Bidas appears for the petitioner. Petitioners, huh?
Supplementary orders, item 19.
As per last office note dated 2/11/2024, your lordship.
Item 19.
Yes, Lord.
Yes.
The related matter which they
No, no, so your technical bid was rejected. On what ground?
But,
On how many ground?
all total 5 grounds,
On 5 ground.
5 grounds. For each, my lord, I had the explanation, and also, my lord, one of the ground your lordship was satisfied, and accordingly the interim order is granted. Now, my lord, the problem is on third, lordship has directed me to take steps within 2 days. I had taken step on 4th. And now on 30th, my lord, the council was, my lord, informed that because the weight is more than 500, so
they have to take back the, the steps and directly send through, post office by, parcel. And, the council has, asked them to, place it before the, Lawazima code. And so that an order can be, passed, and because earlier this code has directed for registered post, we have taken them. Now the office is saying that it has to be by parcel. Matter was sought to be, requested to.
You can send it in two parcels,
Parcel, but that, if you are watching,
maybe it's 800 grams.
No.
1 month has passed, Mr. Council, this is not done.
Further,
You are wasting time, huh?
Plus, we have received communication, instructions from the department, but
no, this is
From-
private respondent. private
from
respondent.
their perusal, it seems that the instructions were not done properly. That's why we have sought for clarification regarding the instruction. That instruction should be coming out. If possible.
But why do you take so much time?
No, court, we have taken steps, then the court, remain closed, on 30th. At the office by telephone, to the, my friend, and asked them to take the, these steps. And he accordingly, asked the, official to place it before the Lawazima so that an order can be obtained for taking, by parcels.
You are a penny for whom? All the respondents except for 5.
Except for private respondent.
We'll take today itself, during the course of the day, the fellowship, the leave, to take by.
You take dusty service also.
Lodge.
Mr. PJ Sakia, Learned Counsel for the petition appears and submits that. Notice could not be sent to the respondent number 5 as the weight of the notice was 800 grams while the permissible limit was only 500. Mr. PJ, the petitioner shall accordingly send the notice to the respondent number 5 by way of 2 parcels / envelopes, both being less than 500 grams each. Full stop. In addition to the above, the petition shall serve notice upon the respondent number 5 through dusty service and file affidavit of service thereafter. The same should be done within 2 weeks. Within 3 weeks, huh? Mr.
M. Lordship, on behalf of Bigo.
Mr. M. Bhuya, on behalf of Mr. B. Gogoi, Learned Counsel for the PWD, submits that further instructions have been sought for from the state respondent. Accordingly, leave this matter on. Give it.
Interim order passed.
Interim order to continue till the next date.
Actually, that to take steps in two,
2 envelopes.
2 envelope by registered post.
Yes,
Yes.
but it's supposed to be ready.
Much observed, Lordship.